Good morning and a warm welcome to the Financial Intelligence Centre's webinar for legal practitioners. Today's webinar, we are going to focus on some key financial compliance obligations that legal practitioners need to know and that they need to apply within their sector. I'll be your MC for today's session. My name is Yolandi Plaikis and I'm part of the guidance and outreach team here at the FIC. I'm joined by my colleagues Sinai Zulu, Kwanele Sabia, as well as Victoria Nsana, and we'll take you through today's session on legal practitioners. Just before we get started, there are a bit of housekeeping rules in terms of a register and a survey. So we will post a register at the beginning of today's session. We ask that all of you guys complete the register, all the attendees online complete the register. You will get a copy of today's presentation, everyone who's completed the register. There will also be a survey that will be posted just towards the end of today's session. Please do complete that survey, give your critical feedback on what you want to see in the next sessions and so forth, and we can then take that into account. Okay, so without further ado, I'll then swap over to the presentation. As I've mentioned, we are going to take you through only certain aspects of certain compliance obligations that are covered in the Financial Intelligence Centre Act. First off, you need to understand who falls within the ambit of a legal practitioner. So item 1 of Schedule 1 to the FIC Act actually sets out who all must register with the FIC as legal practitioners. So if you look at the definition of item 1, you'll see there, it first covers an attorney who actually practices on their own account. That's a sole prop, a person that's practicing solely on their own, not linked to or in partnership at least with other attorneys. There, very importantly, it is a requirement that they have a fidelity fund certificate. So at certain times during the year, we get quite a lot of requests from attorneys on the registration and confirmation of registration information that we need to send through to them to show to the Legal Practice Council that they are registered with the FIC. Likewise, we need to understand, or at least you need to know, that if you do have a Fidelity Fund certificate, you are an attorney, you're practicing on your own account, you must be registered with a FIC in terms of item 1 of Schedule 1. An advocate, that is specific advocates that actually can receive requests directly or briefs directly from the public, meaning the public can engage them directly and they don't have to go through an attorney themselves, and that advocate can receive funds directly from the public. So there again, those advocates have to have Fidelity Fund certificates and be enrolled as such. And there they'd have to register with the Financial Intelligence Centre in terms of item 1 of Schedule 1. Then we've got the bigger law firms, which are the commercial juristic entities. And there they have to register with the FIC per branch that is operating. And there it includes all the partners and members that comprise of that law firm. So it's not necessary for all the individual attorneys that is employed by that law firm to register, but it is a requirement that that law firm register, and it's register per branch. If there's multiple branches within a province, all of those branches need to register as well. So have a look at Public Compliance Communication 47A. It sets out guidance on the scope of item 1 of Schedule 1, legal practitioners, and it also provides some key information on risk indicators, which we'll take you through in a bit. So just a glance at the overall compliance obligations that is set out in the FIC Act. So first off, you must, as an accountable institution, apply a risk-based approach. That's basically where there is a higher risk. You must put more controls in place to mitigate that risk. There, if you want some more guidance around risk-based approach, look at Guidance Note 7A as well as PCC 53A. Targeted financial sanctions. When you onboard a client or when you conduct a transaction on behalf of a client, you need to screen that client. Have a look at Public Compliance Communication 44A that provides guidance on targeted financial sanctions. Customer due diligence and beneficial ownership. When you onboard a client that is a legal person, meaning your client is a company or a partnership or a trust, there you also need to understand who the beneficial owners are. You can have a look at Public Compliance Communication 59 for further guidance on beneficial ownership. Politically exposed persons and prominent influential persons there. When you onboard clients, you must check whether or not those clients are politically exposed persons. For further information around who exactly is a politically exposed person, there's different schedules. Look at Schedule 3A, 3B, and 3C to the FIC Act. Account and transaction monitoring and reporting, which we'll cover a bit more in today's session. We'll cover reporting in a bit more detail. And then training. Obviously, you'll have a risk management and compliance program as an accountable institution. You also need to train your employees against that risk management and compliance program, as well as the obligations as set out in the FIC Act. Governance, it's an important part of any accountable institution that you have a proper governance structure in place and you have a compliance officer that actually ensures that the institution is complying with the FIC Act obligations. Registration on GOML, we are going to cover in today's session a bit more in detail, and my colleague will take you through the steps on how to register and just confirm those steps with you. Risk management and compliance program, so that's a program that you must have in place. It comprises of policies, processes, all the different controls that you have in your institution that ensures you comply with the FIC Act. Screening of employees for integrity and competency. In terms of Directive 8, Directive 8 says that you must screen your employees against the targeted financial sanctions list as well. And then risk and compliance return, that's something that we implemented in 2003 through Directive 6 and Directive 7. It's a questionnaire, an online questionnaire that you must complete. And in today's webinar, we will take you through those steps to actually look at the risk and compliance return in a bit more detail. So in today's session, we're definitely going to zoom in on account and transaction monitoring, registration with GOML, reporting. Very importantly, we're going to cover reporting in depth, and then the risk and compliance return. So just to start off with registration, so there if you look at Section 43B of the FIC Act, it does state that all accountable institutions must be registered with the FIC. There, look at Schedule 1. It sets out all the list of the different types of accountable institutions that must be registered. And the registration must take place on the GOML platform. And there is prerequisite information that you must provide upon registration. There's fields that you must fill in. If you want to get more information on the registration process, there is also a GOML user guide that you can download that's available on the FIC website. You have to register before you can file any reports with the center. So it is essential. It's mandatory for all accountable institutions to be registered with the FIC. How exactly to register? So when you go to the FIC website, on the top left or at least top right hand corner, you'll see a register icon. When you click on it, it actually gives you register or report. It then takes you through to the landing page of GOML. And on the GOML landing page there, you will then see the icons stating register as a person, register as an organization. Accountable institutions must click on the Register as an Organization tab, and they'll complete all the entity information as well as the compliance officer information. We receive a lot of queries from accountable institutions asking how far is their registration and why has their registration been rejected and so forth. In a lot of cases, we found that the institution would actually register and not attach the necessary documents. So there, when you're registering, just make sure that you attach the ID copy of your compliance officer, as well as an authorization letter. An authorization letter is a formal letter. It's on a formal letterhead of your entity. It sets out who exactly is your compliance officer and your compliance officer's name, surname, ID number, and the role, which is either the compliance officer, or if you're registering additional users, you'll state there that additional user's specific role. There is also, in addition to the GoML user guide, there is a public compliance communication 5D that we've published, and it does give you also guidance on how to register your branch, as well as your, so all your different branches. And then it does set out some information on instances where you can set up a delegation structure. A delegation structure being where there are multiple branches registered for your entity, and you want all of those branches to be linked up, and you want your compliance officer to have oversight over all of those different branches. In that type of scenario, you can send through a request to the center to have those branches or separate accountable institutions linked and have it under the oversight of a compliance officer. So have a look at the website. If you know that any of your branches are currently not registered, then please do take the steps within this coming days to actually have them registered as their separate branches and ensure that you're compliant with the requirement for registration in that regard. I've covered a bit of dual registration. So there is in scenarios where you have different accountable institutions registered that's linked to one entity. They can set up some sort of delegation structure, as I've mentioned. There are also scenarios where, for example, a legal practitioner also provides trust and company services to their client. And as you are aware, a trust and company service provider is listed as a separate accountable institution in terms of item 1 of item 2 at least of Schedule 1 to the FIC Act. So there, that entity, your entity would have to register both as a legal practitioner and per branch, and then as well as a trust or company service provider as well. And there that's referred to as dual registration on GoML. Make sure that your entity is registered for all the different categories of accountable institutions under which it falls there. So have a look at PCC 5D. It does set out comprehensive guidance in this regard. So once you've registered, then you do have an obligation to actually first off complete what's referred to, or at least develop what's referred to as a risk management and compliance program. There, your starting point would be Section 42 of the FIC Act. Section 42 sets out what all must be covered in your risk management and compliance program. We have also issued guidance to accountable institutions on this. So look at Guidance Note 7A, read together with PCC 53, which sets out some guidance. What we do advise accountable institutions to do with their, when they develop a risk management and compliance program, cover all the items that is covered in Section 42 of the FIC Act, and you can have 3 distinct parts in your RMCP. A part that deals with the identification and assessment of risk. There, I'd like to pause and highlight that you must have an entity-wide risk assessment. So this means where an attorney provides different types of services. The attorney has a civil litigation department, which deals with notices of motions and so forth. And the attorney firm also has a criminal trial department, which deals with criminal trial. The risks in those different departments are separate and unique. You have to have a risk assessment conducted on each separate department, taking into account the unique risks which applies within that department. So they have that entity-wide risk assessment, looking at all the different divisions of your law firm. You've also got a conveyancing division, which faces different risks in comparison to the division that deals with criminal trials and so forth. So they take into account the different risks that apply within the different business units when you are developing your risk management and compliance program. Document the risks and document the controls. As part of your part 2, you'll then document the controls. So if you identify a higher risk in a certain area, make sure that an enhanced control is put in place in that area. For example, in your criminal trial division, you might question aspects of source of funds or so forth, and you want to apply more enhanced controls around determining source of funds or establishing source of funds of your client. There, you can then also look to putting enhanced steps, like I've mentioned, more stringent measures around determining source of funds or so forth, just as an example. If you consider conveyancing, yeah, okay, so then part 3 deals with monitoring. So you've put your controls in place, you've documented what all you will do and how you will do it to mitigate the risks that you face in the particular area. You must then monitor that those controls work. This is part of standard compliance risk management, where you actually monitor the effectiveness and adequacy of controls that you have in your institution. Does the controls mitigate the risk? Where you see it's lacking, you obviously have to put in place an enhanced control. So have these 3 parts indicated in your risk management and compliance program. Make sure that it covers everything that is covered in Section 42 of the FIC Act. We received quite a lot of questions on whether an entity can have one RMCP that covers multiple different accountable institutions that form part of a group. In that type of scenario, you can have one overarching risk management and compliance program, but you must have separate sections that deal with the separate risk assessments for the different business units that you have. So it must fully set out how you're going to deal with the conveyancing area, how you're going to deal with civil litigation area, and so forth in your RMCP. That risk assessments must be clearly distinguishable in comparison to each other. And that is set out in Guidance Note 7A. You can have a look there. So there's no prohibition against having an overarching RMCP, but definitely the risk assessments must be unique to all the different areas of that group that forms part of that group of accountable institutions. We also receive quite a lot of queries on the structure of a risk management and compliance program. Have a look at PCC 53, which sets out right at the bottom a template that shows a risk management and compliance program. I will warn you in this regard, this template is provided purely as guidance, as an indicator, as a framework that you can follow. You have to customize it. So if the inspections team ever does come to your entity and conducts an inspection on your entity, know that if they find the template is purely copied and pasted and used as such in your entity, there's a high likelihood that you wouldn't have met the requirement of drafting and developing a risk management and compliance program. So when you use that template, use it. with caution. Make sure that you have customized it to your entity. Make sure that the risk assessment part deals with all the different business units of your entity. And also note that this PCC is subject to updating. So when you do use it, look at the updates that is found in the General Law Anti-Money Laundering and Combating Terrorist Financing Amendment Act. Look at the amendments that come forth in also the Paktetara Amendment Act and apply those amendments in your risk management and compliance program. So you'll look at Guidance Note 7A as well as Public Compliance Communication 53. When you've developed your RMCP, you've put all your risk assessments in there, you've put all your controls in there, and your monitoring controls as well. And it sets out how you're going to deal with all the aspects that's covered in Section 42. You must then have it approved by the highest level of authority in your institution. So that's either your board of directors, if you have a board of directors. If there's no board of directors, it would be the senior management or a person with the highest level of authority in the accountable institution. Oftentimes we've seen in larger organizations, this approval function is delegated. So there, be very wary. It is something that the inspections team will check, that it is approved by the person with the highest level of authority, that that person has applied their mind, they're comfortable that all the controls that are set out in your risk management and compliance program actually covers, mitigates the money laundering, mitigates terrorist financing and proliferation financing risks. So don't delegate the obligation. The board of directors must not delegate to any other subcommittee. The board of directors must themselves approve the RMCP. It is the accountable account, their responsibility at least. If you look at Section 42A, I think, there you'll see the responsibility of the board of directors is set out in the FIC Act. Once you've then drafted and documented your risk management and compliance program, there has been a notice that was published sometime in March, which requires you to actually submit a copy of your risk management and compliance program through OnGoML. So you have your approved RMCP that you must then upload on your GoML profile. So in order to do that, you'll log into your GoML profile. You'll go to My Org Details and you'll scroll right. You'll click on My GoML and then My Org Details as indicated there on the top right-hand corner. You'll scroll right to the bottom of that page. There is an upload button and there you will then click upload and you'll upload your RMCP. There's a specific format in terms of which you must name your RMCP. So there, have it named in terms of the year, month, and date, underscore RMCP.pdf. So year, month, and date that it was approved, and then underscore RMCP.pdf. Save it as that on your desktop before you actually upload. Then when you upload, do not click on that red X. If you look towards the center of the page, there's a little red cross there. Don't click on it because essentially you are canceling the upload. So just upload it and then you click on upload and submit request. And there you'll then receive some sort of pop-up that says registration information has been submitted. It comes to the back end, to the team here, will then verify the upload was made correctly. And then you'll receive a confirmation that your information has been updated, meaning your RMCP has been uploaded. It's part of your profile now. Yeah, so that was the request in March that went out. If you have not as yet uploaded your RMCP, please do it without further delay. Our enforcement team is sending out notices of intention to sanction on those individuals, on those entities at least that haven't submitted the RMCP via the GoML platform. Okay, so then that brings us to the next section, and that deals with red flags or risk indicators. And I'm just going to take you briefly through some risk indicators that indicate heightened risk. But please understand that it doesn't mean that if this factor is present in a particular scenario, that it is definitely an indicator of that you must report. You must take into account all the factors combined when making up your mind on whether or not to report through to the center. I think what I am going to do is I'm going to swap over to the PCC 47A, which deals a bit more with the risk factors that the FIC has published. And I just want to swap over quickly. So I hope that came through. I'll just double check from the producers. Has that come through on your end? Yes. Thank you. So just briefly, this is the guidance that we have published, PCC 44A, which deals with, which provides guidance to legal practitioners at least. As I've mentioned earlier on in the session, it provides the ambit, the scope, guidance on the scope, as well as some guidance on the red flags or risk indicators at least. So yeah, here's some of the examples. You can just have a look at them. Legal practitioner is located. So yeah, if your client comes in and you see that the client is located very far from yourself and it doesn't make logical sense, you will want to question why exactly the client wants your services. If it's clear that you don't have the necessary experience or specialist knowledge that the client requires, the client is insistent to engage with yourself, where the client is prepared to pay excessive amounts in fees or charges to you, take that into account. Where the client has changed their legal practitioner numerous times within a short period of time, or the client refuses to provide service, or where the client has actually been refused by numerous other legal practitioners their services. So there is a whole host of risk indicators that you can take into account, where the client pays with cash and so forth. And there, very long list, as I've mentioned, setting out the risk factors. The legal practitioner's client receives excessive capital donations with no logical explanation, where they actually pay funds into the attorney trust fund without reason and request refunds on those payments, where your transaction involves a foreign politically exposed person. The transaction involves a purchase of property with cash, and soon after that property is then used as security for a loan. You would then question why would the client do that? Where payment is deferred to a later date with no guarantee to pay later or no logical or economic reason, where the client's payments are actually funded through a third party. All of these questions, or a government entity. So take note of these risk factors. There are also additional risk factors that we'll send through in the slides when we send out the slides in addition to this. So when you do become aware of any of these risk factors, we will consider the interaction, the engagement with the client comprehensively, take into account all the factors, and then you must see and assess. Do you find the activity or the transaction suspicious and unusual? And from that, then, if you do find it suspicious or unusual, you then file through a report through to the center in the form of a Section 29 report. That is a suspicious and unusual transaction report. So I think there, I'll then stop there for this part of the presentation, and I'll hand over to my colleague Sanai Zulu, who will then take you through the actual report type and more on the reporting obligation. Thanks. Over to yourself, Sanai. So we just working on a bit of a technical issues, and I will unmute in a moment. Thank you.
Awesome. Yeah.
I think yes, are you audible? Thanks.
Okay, thank you. Sorry about that. Good morning once again, everybody. Thank you very much for joining our webinar session today for legal practitioners. As Yolandi has said, my name is Sanai Zulu. I am part of the Guidance and Outreach team. So I'm going to be covering our reporting obligations today. That's around sections 28, 28A, as well as section 29, what is expected of you as an accountable institution when it comes to reporting suspicious transactions and suspicious activity. What is that, when we speak of STRs or suspicious transactions and activities, what does that even mean to you? And in summary, that is a behavior that is unusual and is unexpected or inconsistent with what you know with the client that you'd have to report to us if there are no plausible or explainable reasons as to why a client is behaving in a certain way. Yolandi has covered some risk factors as well as some red flags with you, but when we put focus on the red flags, a red flag can indicate that perhaps an STR needs to be filed because a client may be behaving in a manner that is suspicious or even maybe criminal that you may need to make us aware of. So I'm going to share the presentation with you in a bit, just to go over some of those sections with you. Okay, so there are 4 reporting. Are you able to? Okay. There are 4 reporting requirements that are specified in the FIC Act. One is section 28, which deals with cash transaction reporting. And essentially what that requires is for all accountable institutions to report cash payments that are from the value of 49,000 and going up. So anything from that value of 49,000 and in excess of 49,999, you are required as an accountable institution to report that to us. And the reason for that is because cash is very difficult to trace. And with cash, it becomes very easy for criminals to hide their illicit funds, or at least the source of their illicit funds, and maybe even the source of their wealth. So the reason for reporting these cash transactions is so that if there is something suspicious that is taking place, we become aware of it, you provide us with the intelligence, and we're able to utilize that in our work that we have to do and basically execute our mandate well, which is to combat money laundering and terrorist financing and all the other financial crimes that may lead to or be related to money laundering and terror financing. Then there is section 28A, which deals with terrorist property reporting, and that essentially speaks to reporting property that belongs to an individual that might be involved in terrorism or in terrorist activities or may have some association to terrorist acts, as well as persons that have been sanctioned for terrorist behavior or terrorist activities. Section 29 deals with suspicious transactions. So these are all the unusual transactions that you may identify that go against the normal practices of your business. So if, for an example, a client comes up to you and they would like to purchase maybe an asset, either securities or maybe a piece of property, for an example, in South Africa, and you have agreed on a specific price, or you have communicated that the property maybe it would cost a particular price, but then the client makes a transaction that goes above and beyond that agreed upon price, and then later on they request a refund. That would be a suspicious transaction, because the client is now going against what has been initially agreed on, and there is no plausible reason as to why they have elected to maybe make multiple transactions to you that are not justified, or transactions that exceed the amount that has been agreed upon. That suspicious transaction would have to be reported to the FIC immediately. And then we've got international funds transfer reporting, and that essentially speaks to this part of the Act is focused or is targeted to financial institutions, but I do understand that in some instances there are law firms that may have maybe a financial servicing aspect to them. And if that is the case, then the requirement is that there are funds that may come from overseas, and I think the threshold is 20,000 Rand, where a client transacts funds that are outside of the borders of South Africa going into South Africa, or vice versa, where we are transferring money in rands into a different currency. If it reaches that threshold of 20,000 Rand, then that has to be reported to us. But the focus there is essentially financial institutions, and not so much the other accountable institutions like yourselves, which are DNFBPs, and those are designated non-financial institutions or professions and businesses. Right, so in order for you to understand a little bit more about reporting in terms of Section 28, which covers reporting cash transactions, you'd have to read a guidance note 5B, and that will guide you a little bit more around what you need to what do you need to report to the FIC, and how you can go about filing that report with the FIC. Now, when we speak of the cash threshold, I've already indicated that the threshold is 49,999 and 99 cents. That's provided for under Section 28 of the Act, and that is what triggers this report. And when we speak cash, we're including cash payments or cash transactions, so that is bank notes as well. It's coins, paper money, like I've said, as well as a traveler's check. It does not include electronic funds transfers, EFTs. The report that needs to be filed, it has to be done within 3 business days to the FIC of you having had notice or being aware of the funds having been transacted, and that being a cash transaction made to the business that you're operating in. This is, it applies to when funds are paid to you as an accountable institution by your client, where you've received those funds, or when you are paying out funds to the client in cash, paying an amount of 50. I'm just going to refer to it as 50,000 Rand, because if you round it up, it essentially is 50,000 Rand. So if you are paying out funds to your client that amount to the value of 50,000 Rand, or if you're receiving that amount, you'd have to file in that report to the FIC. Then where you may find that the cash transaction is suspicious, you'd have to report it to us. Now, just be careful of not confusing your CTR with your STR. Yes, it may be that a CTR can end up being an STR. What an STR is, it's suspicious transactions where there's unusual behavior and unusual transaction, client going against what you have both agreed on, which is what I've explained earlier. Whereas a cash transaction, it's about the client walking into your law firm and saying, hey, I have 70,000 Rand that I'd like you to maybe put into my family trust, for an example. Could you please handle that transaction for me? That is when Section 28 is being triggered, and the CTR reporting obligation is being triggered. There's nothing suspicious about that behavior. The only thing we expect of you as the FIC is that you report the cash that is being transacted to us. No suspicion. However, if the client walks into your business and says, I've got 50,000 Rand that I'd like you to inject into or transact into my family trust. I am not willing to tell you what the source of funds is or how I generated the funds, and you have reason to suspect that the client is maybe involved in the sale of drugs, and that is how they've accumulated the cash. That is now where you've got yourself, one, a CTR that needs to be reported, as well as an STR, a suspicious transaction report, because now the client is behaving in a suspicious way, and there may be illegality as well that has generated the funds that are being passed over to you for you to either invest for the client or put into the family trust and invest on behalf of the client. So please be very careful that you don't confuse these two and you have a very good understanding of how they are exclusive, but also they can coexist, and you might have to then file a report based on both. When it comes to foreign exchange rate conversion, this requirement essentially highlights that you may have to file in a CCR with us, even if you have received funds in a different or in a foreign currency from a foreign through a foreign currency, I beg your pardon. So if maybe I'm your client, I will come to you and I've got pounds that I'd like to transact, and those pounds amount to 49,000 Rand and above, you still have that obligation to report to us. So you may have to do that conversion, and if the conversion amounts to the threshold or exceeds the threshold amount, then yes, the report has to be filed and it has to be reported to the FIC. Okay. This is all provided for in our money laundering and terrorist financing control regulations, which essentially requires you to file in these reports to us, and the information that you need to gather as well when you're filing these or when you're receiving the funds, as well as filing these reports to us, that being Section 28 report, a Section 28A report, as well as a Section 29 report. You have to be able to identify and verify your client, which then is part of your CDD process. In any case, the assumption is that you would have gone through that process in any case as a regulated, accountable institution. CDD is basically the first point of call before you even enter into a business relationship with the client. So once you have identified and verified your client, which forms part of your CDD, then that information should be readily available for you in the event that you have to file an SCR with us, or CTR, and other types of reporting obligations that we have placed on you. It doesn't matter whether a transaction has been completed or it is in the process of being completed. Even if the transaction is still, in the process of it being completed, by the fact that you have received an amount of money that exceeds or reaches the threshold that we have placed, you are required to report that to us. Regulations 24, I'm just going to read from the slides here. It says a cash threshold report must be sent to the FIC as soon as possible, but no later than 3 days after a natural person or any of his or her employees. That means any of your employees. There is no designated or specific person that needs to file this report, but anyone that is under the employ of your firm, your law firm, is required and is obligated to report to us as the FIC. So if this person has to become aware of the fact that a cash transaction or a series of cash transactions that have exceeded the prescribed threshold has been made to you, and therefore it would be prudent and it is expected that as an accountable institution, you have filed this report with us, but over and above that, you monitor your bank accounts on a daily basis, especially in the event of cash. Okay, because also it may happen that your client is aware of this report and they may send or make cash payments into your account in tranches. So they make maybe a payment of 20,000 Rand today, tomorrow they make a payment of 15,000 Rand, and now I'm about to expose the fact that my math is not that great, but say we go all the way to 50,000 Rand, and if you total all of that, it becomes 50,000 Rand, and then you file that transaction. So that is why it's also important for you to monitor your accounts so that you are aware as soon as that, as soon as that threshold has been made, because remember, you have a period of about 3 days to file that report with us of you having known about the transaction being made to your business account. Then we've got Section 29, which I have already explained that this deals with suspicious transactions. And always think, is the client behaving in a manner that is suspicious, that is unusual in terms of our scope of business? So you are an industry expert, and we are counting on you to use your industry knowledge and your familiarity with how transactions are carried out within your industry for you to know what is unusual behavior and what is usual behavior. Because what may be unusual behavior in your scope of work, or what may be unusual behavior in your scope of work may be very usual in a different sector, and vice versa. So we're also relying on you as an industry expert to be the one that carries out your judgment based on what you know about your industry and what is regular and what is usual and what is not unusual. So in the event that a client makes a payment to your business that is inconsistent with what you know, if maybe the client had explained to you that the funds will be coming from a bank account that is from one of the South African banks, but then you wake up the next day, you look at your bank statements in the business, or you look at the funds that have been deposited in your business, you find that actually you've received funds in a different currency, maybe in dollars or in pounds or euros. That is behavior that may raise some alarm bells to you. And if you question it with your client and you cannot find a plausible reason for a client having taken that action without you having known about it or expected it from the client, that is when a suspicious transaction report would have to be filed, because now your client is going against what you both agreed on. Okay, so Section 29 covers money laundering, it covers terror financing reporting, as well as the sanctions under the sanctions that a person may have been placed on, that individual for unusual or suspicious behavior, or maybe even a criminal conviction that you may have found, maybe perhaps doing your adverse media checks. Okay, so again, the information that is required there, it's all the information that you are expected to have at the time of entering into a business relationship or establishing a business relationship with your client, and that information would include you identifying, or that process would include you identifying and verifying your client. That is what we normally call CDD, or customer due diligence. There are common reporting errors that we have identified at the FIC, and it would be beneficial, obviously, for industry people to know about these errors that we keep identifying, and this would enable you to file reports that are successful, or that will go through the entire process of reporting successfully without you having to now remediate your reports and not having an understanding of what exactly is expected of you. So we found that there is no non-adherence to defined reporting timelines. Now, we have spoken about a 3-day timeline when it comes to CTR. If that has not been adhered to, that becomes problematic to us. It raises questions as to why the report was not filed with us on time. And also, not all products and services are identified. If you allow us, or if you provide to us the information as to why a report has been filed and the services that you provide, because now that the services and the products that you provide become an indicator as to why what you have identified as suspicious behavior is suspicious to you. All right. So like I said earlier, one sector may operate in a way that is usual. It is usual maybe for a client to make small payments or payments in tranches, maybe because of international regulations that have thresholds that if you are maybe transacting money from outside of South Africa, there still needs to be a tax certificate that has to be issued maybe by one of the regulatory bodies. And so that's why funds will be sent in tranches. That is understandable for one industry, but it may be that within your industry, it may be a totally different story. So if we have an understanding of the product and the services that you offer, and then we couple that with the behavior that is seen to be suspicious, that is when it makes sense as to why you have filed a suspicious report. Okay, there are reports that are not completed in full. Information, we always say at the FIC, is our bread and butter. So the more information that you provide to us, the better. If there's missing information about the client, about their originality, maybe their nationality or where they're transacting from, as well as the transaction itself, it then becomes very difficult for us to identify what is problematic about the transaction that is being reported. Then there are reports that are not being checked before being submitted. It's always helpful to proofread anything before you submit it so that you know that all the information that is needed has been provided, and it has been provided in a succinct way, in a way that enables the reader on the other side to understand what you're trying to communicate to them, right? Not all reportable events are identified. So I guess that it's a learning. It's something that we as a supervisory body, we need to emphasize on whenever we carry out these awareness sessions, because in order for you to be able to identify a reportable event that is a suspicious transaction, maybe, we need to educate you about that and explain very well to you what makes it suspicious and what is suspicious behavior. So I guess it takes us working with you as industry people to make sure that there's that give and take and that there's that understanding. So where you are unable to identify all the reportable events, it becomes problematic, but we also understand that we have to work in collaboration with you to make sure that you understand. And that is why it's also important for you to understand all of, to attend all of our awareness sessions so that you familiarize yourselves with what the FIC requires and expects of you. Okay, and then there's rejected reports that are not remediated. So where you have filed a report and it has been rejected, you have to remediate that report in order for us to use it. I'm not going to delve too much into the remediation of reports. I think Gwanele is going to cover that aspect. Right, so the PCC that you would have to rely on, or the guidance rather, that you'd have to rely on when it comes to reporting suspicious activity as well as transactions, it would be guidance note 4B. Now, there's a difference between a suspicious transaction as well as a suspicious activity. All right. So let me just make an example. If a client walks into your business and they say, well, I'd like you to establish a family trust for me, but I'm not prepared to tell you who the beneficial owners or the beneficiaries of the trust are and where they are located. That is a behavior or activity that is suspicious. Okay, but still falls under the umbrella of Section 29. If the client has established a trust with you, they have provided you with all the information that you needed, but they've said to you, I will make payments or I will inject funds of, say, maybe 100,000 Rand every year into the family trust because we have invested, we've all got all of our passive investments and we're able to do that, commit to a year. But then in that year, you find that actually the client has made multiple 100,000 Rand payments. Some of them maybe are in foreign currency. It's just, it goes against what you know and what you understand and what you agreed upon with your client. That is where Section 29, the STR side of Section 29 is being triggered. So you also have to have a very good understanding of the two. But when we speak of, suspicious and unusual transactions or activities, we talk about proceeds of unlawful activity, where there is a facilitation of transfer of proceeds that emanate from unlawful activity. Maybe it's money that's been made from drugs, and that is a source of funds, or other illegal activity, where there is no apparent business or lawful purpose for the business relationship that the client is trying to enter into with you. There's no reason for the business relationship to exist. That's when you have to, it should raise suspicion and you file that with us. In the event that where you're investigating maybe a business transaction with the client and you can see that the client is trying to evade tax, not to avoid. We know that avoiding tax is legal, but evading tax is what's illegal. So where you find that your client is trying to evade tax, that's when it is a criminal offense and that needs to be reported to the FIC. An offense relating to financing of terrorism, obviously terrorism is an offense, and so that needs to be reported to us as well. The contravention of a prohibition under Section 26, and that all is covered, that basically relates to terrorism and terrorist behavior. That too needs to be reported to us. And any structuring of a transaction or activity which is conducted for the purpose of avoiding giving rise to a reporting duty under the FIC Act. So where a client is trying to be evasive, or they don't want you to report, or they're making very sure they are very intentional about avoiding being reported to the FIC in, where it is reasonable for you to maybe say file in a CTR with us, and the client is trying to avoid that or doesn't want you, is discouraging you, or is making sure that maybe every time they make a transaction, it falls below that 49,000 Rand threshold. That is when you'd have to file an STR with us as well. Where there is no ability for you to identify and verify your clients, again, you'd have to file a CTR with us. Already made an example where a client does not want to disclose to you who the beneficiaries of a trust might be. Or maybe if you look at a company organogram, maybe they do not want to disclose to you who all the shareholders of a company are, or there are some unreasonable and unjustified complexities in that company structure or the organogram. That's when you might have to file a suspicious transaction with us. And your identification and verification process needs to be outlined and reflected in your RMCP. We have to know what information that you obtain from your clients when you enter into a business relationship with them. And you also have to conduct ongoing due diligence on an ongoing basis or during the life cycle of your business relationship with your clients. And what ongoing due diligence is, if there is a trigger event, say maybe your client is due for a review because maybe you have identified them as a high-risk individual, and so you want to review their profile, and you also want to check that has there been any changes, or maybe the client has changed their addresses and now you have to make those updates. That is what ongoing due diligence is where you are constantly or habitually reviewing a client's profile because of other trigger events that may require you or force you to go and relook at the client profile and maybe make some changes there on an ongoing basis. All right, there is no monetary threshold for suspicious transaction reporting or activity reporting. So even if a client is making a payment of 5,000 Rand, something as low as 5,000 Rand or maybe 1,000 Rand to you, if the behavior is suspicious and you suspect that the funds, the source of the funds is illegal activity, you are still obligated to file a report with us. So CTRs, they have a financial threshold, but an STR does not have a financial threshold. You have to also be able to make that distinction between the two. All right, so these SCRs must be filed whether a transaction has been completed or a series of transactions have been completed. It's up to you or you and your understanding of how the transactions need to go. But essentially what we're saying is you don't have to wait until a transaction has been completed for you to file an SCR with us. And knowledge is not necessarily required, only suspicion. The bar is at your suspicion. If you're suspicious that something untoward and something unlawful is taking place, you are required to then report that to us. Who needs to report? It's anyone who carries on the business or oversees a business, manages a business, or is employed in a business. And we have not defined business, the term business in the FIC Act. Therefore, we will use a normal dictionary explanation or definition of the term business. But essentially, if you engage in a commercial undertaking with a client and you're going to be paid for a service and there's suspicious activity that is going on, that is taking place, that is when your reporting obligation is triggered. And then when it comes to bribery, you are also required to report that to the FIC because it is a criminal, it's a type of financial crime that can lead to money laundering. So where maybe, for an example, a politician is using government funds and is trying to launder those funds by maybe putting them into a family trust to ring fence and protect those funds. If maybe those funds were obtained through bribery and corruption, there's still an obligation on you as an accountable institution to file a report with us. Suspicious reports have to be filed whether a transaction has been incomplete or has not yet been completed, whether it's been interrupted, aborted, abandoned, or just ultimately not concluded. Like I said earlier, you do not have to wait for a transaction to be completed in order for you to file an STR. If the suspicions are raised during your interactions with your client, there is that obligation to file the SCR within 50 days or no later than 15 days. And this has to happen during working days, and it excludes weekends as well as public holidays. So when we speak to terror financing activity reports, it's any activity that is in relation to financing terrorism or supporting terrorist causes. Again, whether the action has taken place, you don't have to wait until in the news we hear that an area or a country has been attacked by a terrorist. And so then you realize, oh, maybe my client might have been involved in there. And so I'm going to file a terrorist report to to the FIC, even if a transaction has been aborted, but by mere suspicion of the client wanting or having intentions of making a transaction, maybe to a known terrorist group or to a country that is high risk for terrorism, or to an NPO, an organization that is known to be involved in terrorist activities, and you suspect that that is what is taking place, you are required to report that to the FIC, and you are prohibited by law to facilitate any of that behavior or assist an individual that may have intentions of transacting in that kind of a setup. And this is just a breakdown of all the Section 29 reports and all the regulations that are attached to them. You may have a look at these in your own time once you have received the slides. And like Yolandi said earlier, if you've registered for the session or during the session, you will receive the slides. Now, when it comes to what do you do when an SCR has been filed? Do you let the client know? Do you continue with the transaction, or do you stay and not do anything or hold the transaction? Section 33 of the FIC Act requires or allows the reporter to continue with the transaction unless, and this is where Section 34 kicks in, unless the FIC sends you in writing an instruction not to proceed with the transaction for a period of about 10 days, right? And I know there are concerns of what do I tell the client? Because now my SLA, as far as the client is concerned, is 10 days, or it's maybe 5 working days. And now I have to wait for a period of about 10 days for me to proceed with the transaction. You'd have to find tactful ways to sort of manage your client's expectations and maybe find ways to keep them at bay so that they do not, it doesn't raise suspicion on their side, because tipping off is also a criminal offense in South Africa. So you have to be very careful to not tip them off, but also making sure that you still comply with the FIC obligations. Now, I do know that in the legal space or with legal professionals, there's always this concern about legal privilege and the fact that you have to protect your client's confidentiality. But in Section 30, I will tell you just now, Section 38 actually protects you from being prosecuted or having this report or the Section 29 report being used against you in the event that you have to file a Section 29 report. So everything else basically is trumped by the obligation to file an SCR with us, and you will be protected. You will not be, your identity will not be disclosed. You will not be compelled to go and testify in court after you have filed a report. So there are those protections that are offered to you, even as a legal professional who has to keep to your legal obligation as well to protect your client and to keep confidentiality and the privileged information that needs to be protected. You are protected by the FIC Act in terms of Section 38. Okay, I've mentioned earlier that the report has to be filed within 15 days, and this excludes Saturdays, Sundays, as well as public holidays. Section 23C of the FIC Act requires accountable institutions to keep records of reports submitted to the FIC in terms of Section 29, and records must be kept for a period of at least 5 years from the date of which the report was submitted to the FIC. And when filing an SCR, there are a few things or aspects that you need to note when you are filing an SCR with us. So suspicious transactions and activities are not always detected, and we find those to be the areas that need to be remediated at all times. So when you're filing an SCR report, just make sure that you follow the guide that we have prepared and provided to you, and that you make use of all the mandatory fields that we have placed on the system, on the GoML system. There is a field there that requires you to provide reasons for reporting and the action that has taken place that needs to be reported, as well as the individual, your client's ID or passport number, their address, telephone number as well, and all the other information that may be important for our for us to review your suspicious report that you would have submitted to us. If any of these details are omitted or not provided at all, then it becomes very difficult for us to follow through with working with that STR that you would have filed with us. STRs that are reported with a series of transactions are summarized. the more transactions that are being made into your business account, the more details that you'd have to provide to us so that we can identify or maybe even detect what is suspicious about the behavior. So like I said earlier, the more information you provide to us, the better, letting us know your area of business. I mean, I don't mean the physical location of your business, but the services that you provide and the products that you provide, so that we can identify the suspicious behavior and understand why that behavior is suspicious. Accountable institutions need to provide detailed descriptions or narratives in both reason for reporting and actions. I've alluded to this already. And then lastly, the free text fields that are present in the form to file an SCR reports are not being used to insert data that ought to be captured in other fields on the SCR and the SAR. So where we have designated fields for you to provide reasons, ID numbers, the client's name, their address, and all of that information, where we have provided that information in the field that requires a free text or that allows for you to provide free text, we don't now expect you, or rather we would prefer that you don't provide information that is already provided for in the fields above. And so that essentially covers your cash transaction reports, suspicious transaction reports, terrorist property reporting as well, the remediation of it and the areas that we have found. And I hope that this segment of the section and the entire session really has been informative and helpful in having you understand your FIC obligations. I will now hand you over to Kwanele so that he covers, which I think is the perfect segue into the next session, because he will now cover SCR reporting and how you can go about doing that, and the fields that you'd have to complete in the event that you're filing in SCR. But thank you very much for joining the session.
Good afternoon, ladies and gentlemen. Oh, still good morning from my side, Kwanele. So I'll be taking you through the demo of GoML system. So please, ladies and gentlemen, please be advised that during my demo, I will be working from a test environment. So everything I'll be showing you is not true data, because I can't be showing you production data due to Information Act. So I'll try and keep it as informative as I can, this demo that I'm be doing. So just to make it practical to everyone, I'll start by maybe showing you registration. So when you get to, again, I'm going to reemphasize, this is a testing environment. So everything here I'm going to be showing you is going to be as an example. So for some who do not know, when you register an organization for the first time, you go to register as an organization. That means the organization is completely new. You will be selecting legal practitioners as it applies to you. For me, I'm just going to make a quick example. SK Legals. So please, ladies and gentlemen, please be advised again. The important fields are here. They are marked in asterisks. So please be mindful when filling out your registration forms. Yeah, phone numbers, okay, email. And please, ladies and gentlemen, please be advised also that you only get to use your email once. So if you have multiple organizations, you have to organize other email addresses that apply to them. You can only use your email address only once. For registration, if it does get lost, you can apply to the FIC, and we will change it to the next one that's more relevant, or you can update this email further down the line. I will be showing that during the process. So I'm just going to be skimming through everything here, just so that I can show you. Number 0. The mandatory theory details. My name is just repeating. Yeah. So these will be my organizational details, as you can see here, and then in the bottom here, these will be my details as a registering person. And as my colleagues have stated before, sorry, it is very important when you applying to the FIC, you put your ID document with a clear picture of that copy of the ID book and acknowledgement letter of what role are you going to be playing in this organization. So that acknowledgement letter, can you please have it a letterhead of the company, and if possible, stating that you are the sole proprietor in, sorry, can you zoom in? Sorry. Is it minus 9? Apologies, everyone. I was just being told that it's okay. Apologies for that, everyone. Yeah, as I was saying, when you get to the bottom part of the, so they can float up. Okay, I'll start again. So when getting to the FIC website, when you're registering as an organization, you click register as an organization. In this registering as an organization, you're going to see two fields, the register organization. So this is the organization details that you will be filling out. So this is just an example. And then there will be your personal details. So you as a user who will be logging into this organization, these will be your details. So the username that you'll be using here is very important. That is very unique in your organization. Let me just say one for just to be an example. So this username is very important when you log on. This email is also very important when you lose your username or you want to reset your password. And again, I will reiterate, this email you will only be able to use it once. So you will not use it again for another registration or user registration. And please be advised also, when applying to the FIC, please upload your ID document, a copy of your ID documents, and it should be clear picture. And also accompanied by your acknowledgement letter stating what you will be doing as a user in this organization. And then when done, you will fill in this code as when it's provided, and then you submit the request. I will not be doing this because this email is already I don't think it's used. This just for testing purposes. So please, Benjamin. So again, when registering as a user for an organization, let's say you are applying for SK Legals and the organizational ID is 528, just as an example, ladies and gentlemen. So this is very important that we have the organizational ID when applying as a person to an organization. So this organization already exists in the FIC. So when you're applying to the organization, please fill in this organization number, or you will have to you will be rejected, and you're going to have to apply again as a user. And as again, you have to apply your copy of your ID and acknowledgement letter. Yeah, I hope that gets us through the registration. And now I'll just be logging in to showing you the reporting or the admin part of your organization. So when reporting this German, please be advised. I cannot express it enough how many problems we do experience, as my colleagues were saying, that our common reporting errors. So when reporting, it's very important to know that you cannot walk into the FIC and try and report an incident or an activity or transaction of whatever kind. You will be directed to the GoML website, so the one that I've been showing you. So you do not walk into the FIC and try to report. You will be directed to register and report the transaction on the GoML website. And when reporting, ladies and gentlemen, it's very important that you should know there are two parties for every transaction. That means if your client is, you suspect your client of sending money for some irregular reason, so there will be a transaction leaving your client's account. and there should be also a second party where the money is being received. And if it's being done via an account, you'll have to provide the full details of the transaction. If it's cash, you'll have to provide the full details of who was sending cash or who was accepting cash. So it's always two parties. So it cannot be just my client received money, but I don't know where it comes from. Well, you can, but it poses many questions if you don't have the information. So as you carry on, it's very important that you know that the money can come from a person, entity, or account, or it can go from person to person, or a person to entity, a person to account, and vice versa as that. So this is just to illustrate what I was just trying to explain. And I will be showing this on the demo shortly. Let me just show you as you are here. So if you are logged in, you will go to new reports. You will be most likely using the web reports. Yeah. So this is where you will specify what kind of reports you are reporting. So here's a cash threshold. There is also suspicious activity and unusual transaction reports. So whichever one applies to you. So I'm just gonna make it cash just so that I can show you. So location where this transaction happened. Let's get that. So again, ladies and gentlemen, please be mindful. Asterisks are very important when reporting. If you do submit a report or it does let you submit a report, it will most likely be rejected because there are certain items that are missing in your reports. And do not worry, if it does get rejected, you can still re-amend the report. So filling in the important factors. So indicators can be anything that you notice your client. If your client is being evasive, sorry if I'm speaking fast, I'm just trying to keep ahead of time. So if your client maybe comes to your office with cash and they're very evasive and not telling you what where the cash came from and what transpired when they got the cash or whatever amount, please, these are both indicators, as my colleagues have said before. You will be filling in all of these, the mandatory fields, and I will reiterate. No man. When you're reporting, it's very important to note the how, when. Sorry, yeah. So these are all the factors that are important when reporting. Okay, they're not here. Okay. Oh, fuck it. So the what happened, where it happened, when it happened, the location where it happened, and who was in that transaction. If you can describe it in this transaction fields, it will go very much into your favor that you can describe. That means you are being accountable, that you are keeping track of what your client was doing, or what you if not your client, who was it that was interacting with the client, and how you are being diligent in your reporting. So when you do have a description of what happened, where and how, you can also have a comment section saying what was your role in this, because maybe you are not part of the transaction. So as I said, it's always a two-party system. So it's either from your client or it went to your client. At one point, sorry, at any point, it would go not from your client and to your client. So it's either or. Yeah, so when filling out the details is very important. Okay, sorry. Let me it will not allow me it won't allow me to open these fields until I've filled in these required fields. So it's dates. So it happened yesterday. And now it'll allow me to open these fields. And these are gentlemen, as I said before, you can go from a person to an account, or a person to person, person to account, person to entity, and vice versa. When you fill in all these mandatory parts, you will just add and save. So just to save time, I'll not fill in the whole thing because it'll take quite a bit of time. And once everything has been done or filled in the mandatory fields, you can save. As you can see here, it just created a reports ID. Yeah, so here's a report ID. That means, but then it has not been submitted. So the report is just saved. So that means you can come back. So when the report is saved, you can go to not submitted reports. Here it is. Here's a report that I just created. You can still go back and edit it, finish writing up your reports, and then submit it. When it's submitted, it will go to this folder, submitted reports, and you will find it here. So, ladies and gentlemen, if your report again does come back and it's found that it's rejected, you will have a reason, and when it is rejected, I'm just gonna go here to find some submitted reports as an example. Yes, so when you go to submitted reports, you will find that your reports will be under here. So you won't see other organizations. Only your organization that you are registered to be in, you will be here. So again, this is a test environment, so do not mind me. So when you get here, when you click here, you will be shown what are the reasons your reports are rejected. So in this case, you do not go back and rewrite another report. What you will do from here is revert back. So this report will now be reverted. Reverted, and that means it will go back to the drafted reports. It will be in the drafted reports. Here it is. So now we're in the not submitted reports again. So that means you can go ahead and edit this report, correct whatever that was submitted incorrectly, and then resubmit it again. So that's the re-amending part of the reporting. And in cases where you are the CO or the admin, you are able to see active users in your organization or the organization request. So wait. So let me make you an example of this. So 528. 528. So should details change in your organization, I'll just make an example. So when making a change in your organization, you click the plus sign. And let's say I wanted to change my name to Escape Bets and just rename it to that. So I'm just changing the name. And if there's any document you'd like to upload to say why you're changing it, you can also upload it here, and you will find it when you have submitted the request. So I'll just submit the request. So as you can see here, if you have trying to make a change in your organization, please keep this Shrek number. Ignore the UET. This is just to tell you this is a test environment, but this Shrek number until the end, please keep it for your escalation purposes. So that means this can sit for maybe 2 weeks, and you feel like it should be escalated or fast tracked, you can contact the FIC on a public query system, and if you provide that number, it will go faster and you will be expedited more efficiently. So just to show you how it will be looking. So as you can see here, all FIC will do is to check that Why has the organizational details changed? Does it reflect on other organizations, let's say the NCR or whatever reporting entity that you report to? So all the FIC will do is just verify this and approve and finalize. So that means this name will now change to SK Bets when everything is approved and finalized. And also when you do register as a new user, it all comes through the FIC and will be verified, and will be given the key that it needs to be verified all the way to approval. If not, it will also be rejected. I'll make an example. Should this details not be, if it cannot see why this organization is changed or cannot find the users and so on so forth, it will be rejected as per FIC. Yeah, that's it from me, ladies and gentlemen. I hope my demo was helpful. Yeah. Oh, yes. So for you, ladies and gentlemen, you were changing your org details here on my org. So do not mind my process, but your organization, when you want to change, make you change it to your organization or your user details, you go to my GoML. Yeah, I hope my demo was helpful. And I'll hand it back over to Victoria, if I'm not mistaken.
Thank you, Gwenella, for that. I'm just going to share my my screen. Okay, let me start by introducing myself. Sorry. Good morning. My name is Victoria Nzana. I'm an assistant compliance officer within the guidance and outreach unit. And I'm just going to be sharing for you a presentation about the risk and compliance return, which was an obligation for designated non-financial businesses and professionals. So let me just share quickly. Yes. Thank you so much. Yes, so the risk and compliance return is a questionnaire which the FIC issued to designated non-financial businesses and professionals. And the reason for this was that the center was trying to understand better the risks that are posed to the institutions which we supervise. So as much as the regulator requires its accountable institutions to follow a risk-based approach, we are also required to follow a risk-based approach to supervision. So in the way that we supervise accountable institutions, we should follow, it should be in line with the risks which are posed to you as an institution. And in order for us to understand that, we required designated non-financial business and professionals such as legal practitioners to submit a questionnaire so that we can better ascertain, for example, the nature of your clients, the nature of your transactions, and the type of services that you provide. So this questionnaire was issued in terms of Directives 6 and 7. And with the information that was submitted, the FIC uses a risk rating tool to analyze this data and to identify higher risk designated non-financial business and professionals. So those are basically accountable institutions which are not financial institutions. And this identification of these higher risk institutions was for the basis of risk-based supervision. So you will note that as a legal practitioner, you have to submit the risk and compliance return in terms of Directive 6. So if you haven't yet submitted your questionnaire, just make sure that you navigate. I will explain how you get there. Just make sure that you navigate to our website and submit your questionnaire. This is how you access the risk and compliance return. So first you would go on our home page, and then you would scroll to the middle of the page, and on your right, there's a banner that says file your 2023 risk and compliance return today. Then you will click that banner and it will take you to another page. And on that page, you will check which directive pertains to you as a legal practitioner. You will notice that Directive 6 is relevant for you, so you will complete only Directive 6. And then that information gets sent to us as the center. Just note, for your record purposes, you may take a screenshot of the completion message that you get when you finish the return, just for your personal records, but note that we receive your submission immediately when you complete the questionnaire. Also, before you complete the questionnaire, just make sure that you are registered with the center, because it will ask you for your org ID number. So this is basically your designated number when you register with the FIC, and it's the number that we will use in all our correspondence with you. So just ensure that you are registered and you have it on hand. If you don't remember your org ID, maybe you don't have access to your old emails, you can just give us a call and then we will provide you your org ID number. And if you want to get a sample of what the questions look like, on this very page, there is a link at the bottom right there. You'll see it says download a sample of the RCR questionnaire. So if you just like for your perusal, you can just have a look at the preview, just to have a look at the type of questions that are asked to better prepare yourself. And then ultimately, you will do it online and complete and send to the center. In closing, this is just a summary of the different compliance obligations that we have discussed today and the relevant sections on the FIC Act. We will send you the slides to this presentation so that you can just be able to have a look at this. And there's also the designated guidance products which provide guidance on that relevant section of the FIC Act. With that, we're just going to go into our question and answer session. Thank you, Yolandi.
Thank you very much for that, Victoria. That was very brief, but setting out exactly where to find the risk and compliance return. Thanks to Sinai for setting out what exactly is the reporting obligations. And then obviously Cornelia came in and showed you how exactly to register and also file a report. So I guess as an outcome of today's session, we would want to see an increase in registration, submission of RCRs, as well as submission of reports. If you are uncertain in any of these terms, then today's session should have helped you to understand your obligations more fully. So we have received quite a few questions, which we have started filing responses to in the question and answer box, but you can send through some more. We do have quite a lot of time still left, and we can go through those questions in detail. So again, I'll ask everyone to complete the attendance register as well as the survey. There is a survey link that is posted. Complete that survey link, it's quite important. And that being said, I'll go into the questions. The first one here, for legal practitioners who provide trust and company services, do they need a separate RMCP? So there, I've mentioned earlier on the session that if you are an accountable institution that forms part of a group of accountable institutions, it's not necessary for you to have a separate RMCP as such. However, very important for you to have a separate entity risk assessment conducted per accountable institution, and that per accountable institution must also take into account the different divisions within that accountable institution, the different products and services within that accountable institution, the different clients within that accountable institution, as well as the delivery channels within that accountable institution. So if there is a group-wide RMCP, there must be separate sections that deals with the separate entity risk assessments. For example, if it is an accountable institution that forms part of a group where there is a legal practitioner as well as a trust and company services provider, they can have a combined RMCP, but there will be separate sections setting out the risk assessment that's conducted on the legal practitioner, the risk assessment that's conducted on the trust and company service providers division as well. So have a look at guidance note 7A there. It does speak to that principle. The second question then there is there a definition of what a branch is? I have 2 physical sites, but only 1 file management system and 1 bookkeeping system. So there we don't have a definition as such of branch. Have a look at Public Compliance Communication 5D. It does set out the requirement for legal practitioners to register per branch. And I think there the important point of registering per branch is that the risk that each branch faces is different. The clients that each branch faces may be different. And also the products and services may vary from branch to branch. So we want to see that unique reports and information coming through per branch, ensuring that the risk assessment and the controls that are implemented within that branch is specifically customized and fit for purpose for that specific branch. There it is based on the physical branches. So there if you have separate physical branches, a point must be noted where, I guess, where a branch has the option of working remotely. There, a different type of principle may be applied if you are just working remotely from somewhere else, but you're working for that exact same branch, that exact same customer base, that exact same products and services. There, that's a different type of scenario that you that would apply, and it's not specifically 2 separate branches. It may be just an instance where it's where you are working remotely from an area. One would question, and a follow-up question has come through on this, where the 2 separate branches have exactly the same clients, have exactly the same products and services and so forth. One would question, why would there be 2 branches, the same customer base and so forth? Is that the most effective or efficient way of managing that? Is it a case of just being remotely working from another area? However, there again, the requirement stands. If it is 2 separate branches, even though they share similar clients, there is a requirement to register those 2 separate branches as separate accountable institutions. I'm going to skip over to a more reporting type question, and I'll just ask Sinai maybe to come in and give the distinction, just emphasize the distinction between IFTR reports and CTR reports, and then just emphasize again in what type of scenarios would you file the different reports, IFTR and CTR, who must file an IFTR versus who should file a CTR, please.
All right, thanks for that, Yolandi. So a CTR report would be filed by an accountable institution that would have received a cash payment of 49,999 Rand in cash, all right? And that's either in banknotes, coins, and so forth, or traveler's checks. And then when it comes to an IFTR, that would be a transaction that would be made through a financial institution. Okay, this would be made via an accountable institutions, which includes ADLers or authorized dealers with limited authority. Sorry, actually, those are ADLers, as well as a category of financial services providers that have a direct reporting dispensation under the Exchange Control Act, as well as the South African Post Bank. So the individual that has actually listed these institutions, these AIs, based on Guidance Note 9 in the Q&A session was actually quite correct. Those are the accountable institutions that are expected to file an IFTR report.
Thanks for that, Sinai. So there, the next question again back to RMCP, and the Bianca, thanks for the question that you've posed here. If changes are made to the RMCP, do we have to upload the RMCP each time changes are made? For example, when we attend training and the register is updated, we amend the RMCP, and obviously then hopefully you would get approval on that amended RMCP. So Bianca, best practice in that type of scenario is for you to upload as and when you do amend your RMCP. Make sure that it is the approved RMCP. So have it approved by the highest level of authority, and then yes, you can go ahead and upload onto your GoML profile. That's in line with the request that was sent out in March sometime for the latest RMCPs to be uploaded. Will an accountable institution be sanctioned retrospectively if they adopt an RMCP for the first time? So there, if the accountable institution was operating for quite a long time, and then only they've put in place an RMCP now lately, and they are inspected and it is found that the RMCP hasn't been implemented in prior years, they may face definitely administrative sanctions for non-compliance. We would request that you ensure that you put in place an RMCP without delay. There's mitigating and aggravating type factors that will be taken into account. Just to again come back to the reporting point, because I see there's quite a lot of questions around. Please clarify IFTR reports. Again, Sinai, I'll ask you, if the purchase price for the property is paid from a foreign country to our trust account, are we as the accountable institute, as the legal practitioners, required to file an IFTR?
Okay, the answer to that would be no, because legal practitioners are not financial institutions or ADLers or authorized dealers, as I've listed previously. However, you'd have to, if the payment is made in cash, or it's a cash transaction, and the conversion amounts to 49,999 Rand 99 cents, you'd have to file a CTR. But the responsible accountable institution for filing an IFTR to the FIC would be the financial institution or the ADLer and authorized dealer that would have received the payment.
So, okay, so there, that answers that. Can you provide us with a list of documents where we are required to obtain from our clients for FIC purposes, where we are required to obtain proof of residence or ID for each and every shareholder in a private company? So there, obviously, a shareholder is a beneficial owner. So this question is more so asking what type of documents must we request for beneficial owners? And to that, we advise accountable institution that you actually have the flexibility to determine what type of documents you call for, noting that specifically for beneficial owners, the requirement is to identify and take reasonable steps to verify. So there is some added flexibility when you are calling for documents for beneficial owners. So if you've taken reasonable steps to verify, you haven't received actual documents, but you can show that you have put in place reasonable steps to verify that information, then that will suffice and meet the requirement of identifying and taking reasonable steps to verify the beneficial owners. Just trying to find a different type of question. Yeah, there's a question, Sanai. What should be done if a client is just not bothering to respond to requests for FICA information despite follow-up emails and calls?
Okay, so if that client is not responding to the requirements, and the suspicion is that they are deliberately not responding because the conversation has come to, well, I need to conduct CDD and I need to be able to identify and verify you. If that client is deliberately, not responding and has turned around from your business relationship with them, and the suspicion is that it is because of this reason, then I would advise that you file a suspicious activity report, because again, it is reasonable for an accountable institution to ask for this information, and if you provide those reasons and an explanation that it is a legal requirement for you as an institution to obtain those documents and that information, and the client is then not participating or not cooperating with that, yes, I'd say file an SAR with us. However, if maybe there are other reasons that are legitimate, or if there are reasons that the client may provide or may have provided to you, and if those reasons are maybe legitimate, and you will then apply your mind and your judgment as to the legitimacy of those reasons. If they still, they still raise suspicion, then I'd say yes, please file an SAR with us. However, if those reasons are plausible and you're able to then better assist the client to provide you with that information. A typical example that I always use is if maybe the client is unable to provide, let's say, an ID document or a copy, for an example, of their ID, but perhaps maybe they could provide a passport, and the reason for them delaying is that you may have maybe in your requirements said, could you please provide us with your South African ID? And they are now delaying because they do not have that document. Maybe they've lost their ID and that's causing the delay. Then you could provide alternatives to complete, to achieve the same results. So it will all depend on the scenarios. And I always say that in compliance, you have to apply the it depends lens, or you view everything at an it depends lens, where it depends on the reasons that are provided and the legitimacy of those reasons as well. You'd have to make that judgment call.
Yeah. Then the next question there, in the legal profession, by the very nature of the work we do, it becomes difficult to ensure to do FIC compliance before the business relationship is established in all circumstances, especially, for example, with court work or criminal work, if your client is held in custody, etc., and is not able to provide all of the documents you may need to do FIC compliance. How does the FIC view this, especially taking into consideration the element of when a business relationship is established? So there, again, I would refer you to Guidance Note 7A. It does set out a principle around the timing of verification. So not in all instances are you able to get all the information that you require and documentation for verification that you require upfront from the client before establishing the business relationship. That does not prevent you from taking the first steps towards entering into the business relationship. However, before you actually conclude or finalize that transaction, you have to take all the steps to finalize the identification and verification of your client. So initially, when you do engage the client, you get the brief from the client, and you can start working on the client's matter. But during that course of that business relationship, and before you receive your payment from that client for the specific services that you are rendering, you must complete the CDD process. You must ask that client to provide, by however means that possible, the information, and then also you'll have to verify that information against external, independent, and verifiable sources. So that timing of verification principle is set out in Guidance Note 7A. I think it also applies to this comment of, if the money is paid to us to hold in trust for someone else, do we put our bank account in as receiver or the client, or for whose benefit it is placed in trust. Again, when you engage your client before you receive any funds from the client, you would have started the process to identify and verify the client. You can engage the client, but before you finalize that transaction, you would have gotten the necessary information from the client. I'm trying to find another question. If you verify a client's address on SIPC report and it differs with that which is provided in the absence of any proof like rental agreement or utility bill, I assume we then would go with the SIPC, right? I see a response is posted here. So there you would go with the latest information. It might be that the client information around the address, they've changed address from when the SIPC report has been updated. So the information that the client provides to you, if you're able to if the client is able to provide you with a later rental agreement or a later utility bill in comparison to when the information on the SIPC database was updated, you can then accept that on the face of it as a means of verification of information provided by your client. I'm just filtering through the questions to try and find a brand new one. There is a question: as attorneys, we are not trained in the methodology to perform risk assessments to give the level that you require. Would you consider giving training on how risk assessments should be approached? This is very specialized type of work, and having risk assessments done by professionals are expensive. You may consider that the reason why attorneys are not complying. So there, we do have a specific risk webinar series that we've provided in the past. Sometime in December was our last risk series. It was a 5-part webinar series. In the next quarter, we will also have a webinar that's focused on risk assessments, how to conduct risk assessments, how to document them, and so forth. So do have a look out for that. I would also guide you to looking at Guidance Note 7 and PCC 53 because it does set out guidance on risk assessments as such. Yeah. It looks as if we have actually covered of the other questions that came in. What happens if your registered organization did not upload the required documents? Please ensure that you upload your RMCP without further delay if your organization has not yet uploaded it. Your organization does face the risk of administrative sanctions for that non-compliance. There's a question of how often do we need to submit risk and compliance returns? Will the accountable institution be notified when this is required again? So in 2023, Directive 6 and 7 was published. Since then, if you have submitted your risk and compliance return successfully, then you fulfilled the requirement as such. There is not yet a new directive published calling for a new compliance return. When there is in future a new directive that comes out calling for updated risk and compliance returns, that will definitely be communicated to all accountable institutions. For those who have submitted their RMCPs via the GoML platform, please do bear in mind there is a back-end verification process that does take place, and it does take around 10 days from time of submission to time within which you will receive some sort of indication that your information has been updated on the system. So just bear in mind there is that time period. There's another question here, and I'll ask Cornelia. Cornelia, we have been unable to log into our profile and cannot change passwords. Please help clarify the issue, as we no longer have access to the FIC profile and cannot re-register. Cornelia, what is the steps that this person can take in order to remedy this situation? So they say that they can't access their profile and they can't change their password. What can they send through to us or tell us?
The name of the organization, the organization ID, the compliance officer that is registered on the profile, because we can't now give them details of how they log in and who is registered on that organization if we don't know who they. Okay, sorry, let me just go back. As per Directive 2, it is on the onus of the accountable organizations to update their login details, their company details and user details in order to keep up to date. So in this part, you're going to have to write to the FIC via the PQP system, public query system, providing such details as who was registered, organization ID. If you have those details as much as you can, we can assist you faster and better. So your public query system is a way to go. I'll give you my personal email, but that's not allowed, unfortunately. I'll get too many requests. So just please look about the PQP system. It will come to me fast. We will help you. And for those who can't do the RMCPs, please also go through your RMCPs. We are approving them and rejecting some of them if they are not up to par. So yeah, the PQP is your best solution if I can't help you today in the comments.
Thank you so much for that, Cornelia. And I guess on that note, I can then say thank you to everyone who's attended today's session. If you do have any comments, queries, or so forth, send it through via the compliance query portal on the FIC website. Again, there is a survey that we are going to post. Please do send through your comments or questions, any suggestions for future sessions. We'll take that into account. Thank you to all the presenters, my co-presenters, and the producer as well. And until next time, goodbye and God bless. Thank you very much.